We'll start, or you can see only 19 people have joined. Usually it is 24 or 25, right?
Yes, sir.
So any doubts from the previous class? Hope you are revising continuously.
Yes, Manoj.
Okay, let me ask you a question. Okay, A Limited is a public company. Okay, A Limited has a subsidiary called B Limited, which holds say 75%. Okay, now paid up capital of B Limited is 12 CR, 12 crore. Now tell me the applicability of CSR provisions.
Paid up capital, we cannot determine CSR committee.
Exactly. So with paid up capital, you cannot determine whether your CSR provisions will be applicable or not. Correct?
Yes. And since holding and subsidiary individually will be need to commit CSR.
Exactly. Now tell me the applicability of audit committee in this case.
A Limited will be only holding the responsibility, right? For audit committee. Because B is a subsidiary of A, right, Manoj?
Correct.
So the A's audit committee will be the one. In terms of capital, if we're talking, okay, in terms of capital, then it could change. I was thinking in terms of A, not that.
You understood the question, right? A Limited has a subsidiary B Limited. A is holding 75% of the capital. Okay, so B's paid up capital is 12 crore. Now tell me the applicability of audit committee for B, company B.
They have to form audit committee. 10 crore and above.
Reason?
10 crore and above.
Simple. 10 crore and above you need to form.
Correct.
Right. Now you tell me if B Limited is a private limited company.
No matter what, they have to form audit committee.
Even for a private company, is it applicable?
No.
Yeah.
Sure.
Every listed company.
Okay.
Okay. Private. Oh, private company, they don't need to form.
They need not form, you're saying?
Yes. If they are listed company, they have to form.
Okay. What about in the given case?
They don't have to form a committee.
Okay. Anyone else? A is a public company, holding company, which has invested 75% of the capital in B company. B is a private limited company having capital of 12 crore. Whether audit committee is applicable or not. Nobody.
Whether a public company owns a private company, still that private company will be a private company, right?
No, you've got the concepts wrong. Initially, you remember we discussed if a
Acha.
public company has a control over a private company, it becomes deemed public company.
Okay, correct.
So, which means even if you are a private company which is held by a public company, automatically you stand to become a public company and automatically all the provisions applicable for a public company becomes applicable to you.
Okay, yeah, correct. Sir.
You were able to remember or not this initial definition clause that we discussed?
Yes.
See, basic concepts don't go wrong. Otherwise, you will get the entire thing wrong answer.
Yes, sir.
Any doubts, anyone on the till now, whatever we have discussed, any doubts? I'll wait for 5 minutes. You can ask me, you will clear it out. No doubts?
No, sir.
The constitution of audit committee in terms of a dormant company is also required. It's like if a public listed company.
Three exemption we saw. One is supposed to be WOS, wholly owned subsidiary.
Correct.
Correct. Another one was dormant.
Dormant, and the other one is a JV.
Correct. In terms of a JV, you did not constitute.
Okay.
Okay. So JV is anything between 20%
companies.
20 to 50% is a JV.
Okay.
Significant control.
Okay.
In that case, you're exempt.
Okay. Which means if one company holds 20 to 50% of another company, that means the company A will be exempted.
Correct. So company which controls the other company by associate company, so the other company need not constitute the audit committee. Okay, listed company holds 99.99 shares in private company. Private company has capital of 50 crore. Nomination remuneration committee, whether it's applicable or not. Listed company holds 99.99% capital in private limited company. Private limited company capital is 50 crore.
So we're talking about company A holding 99% stake in a private company, and the company B's paid up capital is 50 crore.
A is a listed company, B is a private limited company.
No, because not required, because the company A holds the major right. So company A will only take care of the decisions of recognition of company B, because the board is same, right?
It's not wholly owned, right? Because 100% they have to own. So private company need not form a committee.
Need not or need to?
It's not a listed company, private company.
But who is controlling that company?
A listed company.
Obviously, listed is public company, no? So the moment public company holds control in a private company, automatically private company becomes deemed public company.
The moment they cross 51%, right?
Correct.
Okay, so that means they have
to form.
No, you want me to brush up the initial definition provision?
No. why we get confused is basically because see, company A is holding 99% stake in company B, which means it has already crossed the majority stake mark. And because it's a 50 crore one, so because the parent company A is a public listed company, it's by default becomes a deemed public listed. So they have to, because the first point which says is all public company with a paid up capital of 10 crore, because it's a deemed public company and already the turnover is 50 crore. So by default they are falling under the category of NRC.
Correct. Correct. Which means, see, understand, whenever a listed company or a public company controls a private company,
Okay.
automatically the controlling whatever the status of private company becomes deemed public, which means you are nothing but a public because you are controlled by a public company.
Whatever the parent company status, that automatically gets transferred to the holding company.
Yes, which means if a say listed company is holding more than 51% in private company becomes public, deemed public. That's all. If a public company controls more than 51% in private company becomes deemed public.
Okay, sir.
Right? Don't get this concept wrong.
This
Okay,
is the
so
only
tomorrow
point
you
I
will.
got confused.
Yeah, Siddharth?
This is the only point because the deemed public and one.
Deemed public is nothing but deemed to be, which means you are a public.
Yes, it's almost done, but that 1% is the one which is holding back.
Yeah. So just whenever you are reading a question, that's what I said. First, understand what is the status of the company, whether it's a public, private, listed. Then you go for the provisions.
Okay.
Whenever the moment you establish this relationship, no public and private, then you can determine whether it is applicable or not.
Yes, sir.
Okay, what happens if private company holds 51% shares in public limited company?
They cannot own, right? Public will not be having more than 51%. How can they?
They can. I think
See, in such cases, in reverse cases, status of public does not become private. Status of public remains public. Only vice versa case, it is deemed public. Otherwise, the status is same. A company, private limited, holds more than 51% in B limited, B public company. In that case, B does not deem to be private. B status is public only. However, if A is public and holds more than 51% in private company, B private company, then the status of private becomes deemed public, which means you are a public. You are a public company, right?
okay.
You can note down this, don't forget this, very, very important to determine the status of company. So tomorrow if they ask you that they established this 2-3 relationship, A limited holds 100% in B, B holds 51% in C, determine the applicability of audit committee or NRC committee. So in that case, you should be able to determine whether it's applicable or not, right?
So Manoj, just now when you showed the reverse action of a private company holding 51% of stake in public company, then in that case, what will be the state of NRC?
Nothing. As a standalone public company, if it is applicable, it is applicable. Otherwise, it's not applicable.
Okay.
You are a public company only. Your status does not become private by virtue of shareholding.
So if the conditions of NRC fulfills, then the public listed company will have that, which in case it is a public listed company, but if the turnover is more than 10 crores, it automatically will have to constitute an NRC.
Correct. So two things. One is listed, that is public listed, or just public unlisted.
Okay.
Okay, so both are public. Without going public, you cannot tap the market equity. You cannot list your equity shares on NSE, BSE. You remember the definition? There was 3 or 4 exemptions that we saw for a listed company. Listing of NCDs through private placement and all, debentures. So those are not listed companies. So any doubts on status of holding and subsidiary? Very, very important. This is very basic because going forward, there are a lot of cases where if you don't understand the relationship, then you will not understand the concepts. See, Tata Sons. Tata Sons is a private company which is the ultimate company. It's a private limited company. So that company holds entire Tata Group. Right? It has more than 51% in TCS. It's a listed company. Private company has control over listed company. So by default, private company does not become listed or a public company. If it was a vice versa case, it would become public company. Since my controlling itself is private, other provisions does not directly apply as a deeming provision. Got it? Any doubts?
No, this was great.
Others, any doubts? I actually don't see others not active. Maybe you're understanding or not, I'm not sure.
Manoj, just now I have come back from office. Just now I've just logged in. So
Okay.
yeah, I'll just start interacting now.
Yeah, you can start. Others, any doubts?
No, sir, clear.
See, once you start reading, then you will have doubts. So we can get that clarified. I don't think you guys are revising, or I don't know how it is working with you guys, but all I'm going to say is if you don't revise on a day-to-day basis, it's going to be hectic at the last. Syllabus, as I said, it's huge. Right? You need to, on a day-to-day basis, you need to start reading, make notes for yourself, understand the concepts.
Sir, what is section 149? They have said.
Yeah, 149 is Board of Directors section.
Okay.
We'll deal with that. Where are you reading that from?
In one provision, they say that in the committee where there are 3 should be formed, right? In the directors should be 3. So wherever in the 149 section, according to that section, only 2 should be formed. So they can have only 2. That's what they're mentioned there.
Okay. It's a Board of Directors. We'll deal with that in this chapter, Directors chapter. Okay, come to page number 692. Look, if you have not started reading, I'm saying please start reading. You have ample time. Start revising the concepts. Okay, then start making notes. Otherwise, at the last, if you want to do it at once, I'm pretty sure you will not be able to do it because you might have forgotten the concepts or no one will be there to help you at that point of time. Right, at least now if you revise and come back the next class, we can discuss and get it clarified.
Yes, sir.
Okay, 692, Directors chapter. Are we good to go?
Yes, Manoj, we can start.
Okay, so if you remember in the last class, we discussed about board and board committees, right? Now, who constitutes this board? We spoke about board, correct? So board is constituted by directors. Okay, so all directors collectively form board. Right? So all actions done by directors collectively will be a decision of the company, right? Collectively they will be referred as board. So that is why you remember we started writing about directors report, boards report, right? So it's a collective report. So all decision at the board level are made collectively by all the directors, that is majority directors, right? That is a board. Mandatory individuals must be there. You cannot have any corporate as a director. Please remember, only individuals can become directors. Who can be directors? Only individuals, right? Company cannot be directors, right? Your LLPs cannot be directors, your partnership firm cannot be directors. They can hold shares in the company, but they cannot be directors. Only individuals can become directors. Reason being is, company, as we discussed initially, is artificial person. It cannot act on its own. It needs individuals to act on behalf of the company, act like a agents on the form of fiduciary capacity, right? Like a trust and trustee. We're able to understand, right? Company per se does not have eyes, ears, nose. It has to act through directors. Correct? So remember, directors must always at all time be individuals. It cannot be company, it cannot be your LLP, partnership, or no other body corporates. That is one precondition. Directors must be individual. Second, directors must have DIN, directors identification number. Mandatory to be appointed as director. Please note down. DIN number. Without DIN, you cannot be appointed as director of the company. Director identification number. Right? Tomorrow, if you are going to be appointed or I'm going to be appointed, I need to apply for the DIN, then only I can be appointed as a director. Where to apply? I need to apply to MCA, Ministry of Corporate Affairs. There is a form called DIR 3. You can note down. Form DIR 3. Application for DIN. So by using that form, I can apply to the government and government will allot director identification number. It's a unique number which is only applicable to me, like an Aadhaar number. Without that number, you cannot be appointed as a director. Please remember. Siddharth does not have DIN. If company proposes to appoint him as a director, it cannot do it because he does not have DIN. Okay, DIN is a 8-digit number. 8-digit. Any doubts still here? Okay, can somebody repeat what I just discussed? Very, very important chapter, director. You will have one question or two questions mandatorily from this chapter.
We discussed about two topics called director. A director can be an individual. It cannot be an LLP or
Correct.
a company by itself.
Correct. Correct.
The group of individuals who are directors forms the board.
Correct.
And every individual who is appointed as a director must have a DIN number, which is of 8-digit.
Exactly.
And the DIN is applicable that for getting the DIN, they have to fill a form called DIR 3 with the
Correct.
MCA, and after receiving the number, they can be appointed the director in any company.
Exactly. Any doubts still here? Right. So this is lifetime number. Okay. Once DIN is allotted to any particular individual, right? Kushal or Preeti, anybody DIN is allotted, it remains till the death of the company. I mean, death of the individual. Right? You can't have multiple DINs. Only one DIN for all the companies in which you will be appointed. Right? It is not like one company you will appoint, another company you need to apply for separate DIN. With one DIN number, you will be appointed in all the companies using the same DIN. Any doubts?
No, I think because I have to always edit to MCA rules because I have to always update my DIR3.
You have DIN.
Yeah,
Okay.
so I have to do for me and for my mother because we both are director in our home company.
Okay. Nice. So got it? Any doubts still here? Irrespective of how many companies that you are appointed. Okay, tell me what is the maximum number of companies in which a director can be appointed?
20.
20.
Correct. Out of which how many is public? 10. Got it right? Basic 10 and 20.
Yes, sir.
Okay, so in order to be appointed as a director, you need to have DIN. DIN is only a digit number, which is once you get allotted DIN, then that goes with all 20 companies. Okay?
Yes.
Any doubts still there?
No, director and then both are clear.
Okay, so I think in the year 2006 or 8, I'm not able to recall when was the DIN actually made mandatory. Earlier, DIN was not mandatory, right? So earlier people used to get appointed using PAN number or whatever ID proof that they had. Basis that they would get appointed. But now it's not the case. You need to have mandatory DIN number. So once the DIN provision was introduced in the Companies Act provision, okay, so as a part of what do you say, giving respect to Ratan Tata, the Ministry of Corporate Affairs gave Ratan Tata number 1, DIN number 1, starting with number 1. So Ratan Tata holds DIN number 1. Okay, so in order to give him that, he's a veteran, obviously, right, in the industry. So that is why the moment this provision was introduced, government made sure that he has the number 1 DIN. That is, the rest 7 will be zeros and only 1 will be there. Total 8 digits, right?
Yes.
0, 0, 0, 0, 0, 0.
Zeros and numeric 1.
Yes, yes. You're able to understand.
Yeah. I think it was 2006, I think, when the DIN was introduced.
Correct. Maybe I'm not able to recall exactly the year, but
it's mentioned here in the material that in 2006, first time the DIN was introduced, which is
where is
8 characters. In the director's identification.
Yeah, correct. Sorry, it's here. Yeah, correct. Sorry, it's here in DIN. Okay.
Yes, 8-digit unique identification number that has lifetime validity.
Okay, so any doubts still here?
No.
Okay, so whether a minor can be appointed as a director is a question. Okay. So if you remember your Contract Act, Indian Contract Act, minor, he has to act through your guardians, right? He is per se individually is not entitled to contract in his own name until he attains the age of majority. Correct? So as per the Companies Act, even if he acts through guardian, he cannot be appointed as a director. Right? First, he need to be a major. Okay, he needs to be a major, then only he will be allotted DIN. Otherwise, he will not be allotted DIN. Right? Because otherwise, if there is any liability for the non-compliance, then government cannot sue that person, right? Because he'll say, I'm a minor. So that is why government says nothing doing. Only people who have attained the age of more than 18 plus or 21 plus in that case will be eligible for appointment of director, appointing as a director. Okay, so remember, minor cannot be allotted DIN and he cannot be appointed as a director of the company. Any doubts on minor being appointed as a director?
Can you just explain once again in short? The minor.
See, it is given in above that DIN number is there, no? Above that it is given a minor. A minor will not be entitled to.
Got it.
Right. So minimum age is 18. So post attainment of age 18, he will be allotted in. He can apply for DIN. Right. So only basis DIN, as we discussed, he will be eligible for appointment as a director. So this is specifically with respect to directorship. Okay. Now, who is a director? We spoke about directors collectively form board. Director is a person who is being appointed to the board. If he is not being appointed to the board, he is not a director. So once he is appointed to the board, then all directors collectively will be called as board of directors or a board. Right?
Yes, sir.
Any doubts still here? First page, basic concept. DIN number, directors. Okay, come to page number. Okay, so one more thing. See, this, as we said, in order to become a director, you need to have a DIN. So even if you want to incorporate an LLP, limited liability partnership, you can have the same DIN for LLP also. Right? You want to become a designated partner. The form will ask you to enter your designated partner identification number. Same, your DIN number, 8-digit number will go in the LLP form also. Same number can be used. Right? LLP is separate. You can have how many partnership in LLP. You can be appointed even for more than 20 also. There is no restriction. For a directorship, only 20 restriction is there. Okay. Now procedure to obtain DIN 693. Okay, suppose you want to incorporate a new company, right? Today you want to start a new company, you don't have DIN. There is a form called SPICE, that is an incorporation form. That form allows you to, in the form only you can apply for 3 DINs, 3 directors DIN using that form, SPICE form. Okay, suppose you want to have 5 directors initially who does not have DIN at all. Maximum you can have is only 3. Initially incorporate with 3 DINs will be allotted. Then after incorporation is done, then you have 2 directors on board. Apply in form DIR 3. Got it?
The SPICE and DIR 3 is different, is it, sir?
SPICE is initial, company is not incorporated. This is an incorporation form. DIR 3 is a case where company is already in place.
Okay.
You need to appoint that person as a director in the company. Now, Infosys is already there, Infosys Limited. You want to have somebody appointed as director in Infosys Limited, you need to file DIR 3 form.
Okay. If it's a new company, then SPICE.
Correct. SPICE allows maximum 3 directors to apply DIN. Okay. So once you incorporate company, then you need to file this DIR 3 form for balance if you want more than 3. Got it?
Yes, sir. Clear.
Any doubts still here, others?
No.
Okay, so if you remember initially we discussed, we have moved from manual process to all e-forms now.
Yes.
So how do you sign the document? There's something called as digital signature, DSC, digital signature certificate. Right, it will be like a pen drive. Okay, so it contains your electronic signature. So using that pen drive, you sign the document and then upload it on your MCA website. There is no physical taking printout and signing now onwards. Meaning after this MCA 2006, after this 2006, There is no manual filing. All physical filings is done away with. Now only e-filing is done. Right? So how do directors sign using this pen drive? That is digital signature. Okay, so that is called digital. So usually it is valid for about 1 year, 2 year, 3 year max. Then you need to get renewed. Okay, it will be like a pen drive. I don't have right now, but I can show you. It is there in my office. Okay, it's just like a pen drive. It contains individual's signature. It's a token like a signature. Using that signature, you enter your password. Okay, affix the signature, then upload the document on the website. Same goes with your income tax portal also. Right, same goes with your ROC portal, that is MCA. Okay, so whenever you are filing incorporation form SPICE, you need to have digital signature of all the directors. Whenever you are filing DIR3, you need to have digital signature of a proposed director who is getting appointed. Digital signature is a prerequisite. Before filing DIR3, you need to have digital signature first. Because you need to verify that form, all the details given in the form are correct or not. Okay? Any doubts still here? DSC? Got it right?
Yes.
Okay. Now let me show you how exactly this DR3 form looks like. Then we can cover one topic. Is my screen visible?
Yeah.
Yes.
See, this is a form DR3, okay? See, application for allotment of DIN before appointing him a existing company or LLP. So what does it contain? It contains the applicant's name, father's name, whether citizen of India, nationality, okay, your occupation, okay, education qualification, your income tax number, passport number, driving license number, address, present address, permanent address, okay. Then you need to have this attachments. Okay, you need to attach documents like your Aadhaar. Okay, your Aadhaar should be self-attested. Okay, your consent letter. Consent, consent that look, I hereby give my candidature for my appointment as a director of the company. You need to give this consent, okay, to be appointed as a director. Okay, your PAN, passport, your specimen signature. Okay. See, this is the digital signature to be digitally signed by the applicant. So it's a pen drive, I told you, right?
Yes.
So this pen drive, when you affix, you need to enter the password. Okay, certification will be done by the directors, the company in which you are proposed to be appointed as a director. That company, one director or a company secretary is there. He will certify this form. Okay, got a basic idea of how the form looks, DR3.
Yes.
Yes.
Okay, same thing it is written. See, in page number 670, 693, point number B, 2B, form DR3 form. Okay, applicant's name, declaration. Okay, this is what I just showed you. But important one is 695. Mark has highlighted reasons for rejection of DIN application. Very, very important. You will be asked for 4 marks. Basic reason. See, proof of identity has not been attested by authorized person. I showed you right sign.
Yes.
That signing has not been done. You just uploaded the documents. Form will get rejected, which means it will come back to you as a resubmission. It will come back to you saying you have done this, not done this correctly. I'm giving you one more chance. Please rectify this and file again within 10 days or 15 days, as a case may be. Correct? Proof of residential address has not been attested. Supporting documents of ID proof not valid. Okay? Date of birth is not matching with the date of birth mentioned in the address proof. Your PAN number says one thing, but in the form you have entered something else. Okay, father name is not matching. Gender is not correctly entered. Address proof not attached in the application. Okay, minimum you need to write 8 to 10 points out of this 20 in order to get 4 marks.
Oh, 20 points.
Minimum 8 to 10 you need to write for taking 4 marks. Very, very important question. Reasons for rejection of DIN. Very basic it is. If you read it, you will understand. If you are able to recall that form and then do it.
There's no specific order, right? Out of these 20 points, you have to write at least about 8 points when you are writing. It's not that you have to go in that sequence, right?
No. You can write whatever comes to your mind. Out of this 20, you can write. This all general rejection points. So this actually is given in DIR3 help kit. So usually I showed you this form, right? So this form contains help kit. So whenever people are doing for the first time, they can go back and refer to the help kit, then start filling up the form. Suppose a fresher wants to fill up a form, he can always go back and check the help kit.
Luckily, I have
right in the help kit.
all these forms copies because when I registered my CA, he print out everything and he gave it to me for help.
Correct. So any doubts still here?
No.
Any doubts, others? Please, you can ask me here. See, we are all here to learn.
No, it's clear.
Yes, sir, clear.
Okay, so once, yeah, Pooja, any doubts?
No, sir.
Yes or no?
No, sir.
No. One question here is, in terms of DIN number, okay, when a company is appointing a new director, if the director already had the DIN number, it will be used, right?
Exactly. If he already has a DIN, then this process is not applicable.
But if it's a fresher and the first time it is coming, then we need to get it at DIR 3, then the enrollment happens.
Spice, right?
Spice is initial at the time of incorporating a new company.
Okay, yeah. That's what he said.
After the registration, any new director appointment is only through DIR 3.
Correct. Any doubts? Still here?
No, sir.
Okay, so the moment you file the DIN application, the ministry on verification, if it does not find any evidence of rejection, the given 20 points and others, if it does not find any of these points, right, it will approve your DIN. Okay, so individual person gets an email, gets an SMS to his number, he will be allotted a DIN application number. Right, so DIN allotment number. He will get a DIN allotted to his name once the application is approved by MCA. So usually it takes usually takes maximum 1 day. Okay, or sometimes it may be STP. The moment you file the form, within 5-10 minutes your DIN number will be allotted. Okay, but later if the government finds to know that you have done some forgery or your documents, whatever you have given, is not in synchronizing with whatever you have mentioned in the form, then it will send you for resubmission, ask you to rectify the form. Okay, so in that case, it will be conditional DIN. You can't use the DIN till it is approved DIN. Okay, the form has to get approved. Okay, so take example, I have filed a DIN for myself. I have entered Bangalore details. Okay, so tomorrow I get a job offer in Mumbai. I go back to Mumbai. Or say a company in Mumbai wants to appoint me as a director. So I relocate to Mumbai. Okay, so now I want to change my address. Initially in the form I have given Bangalore address. Now I want to change the address to Mumbai. In that case, you need to file form called DIR 6. Any change in the particulars, any change, your name, your father name, your other details, your address proof, okay, anything, you need to file DIR 6, form DIR 6 for any change in the particulars which you have already reported with MC earlier. Any doubts? DIR 3 and DIR 6.
No. DI3 for registration, DI6 for change amendments or changes to particulars.
Correct. Your DIN number cannot be changed. Remember, that is lifetime. Only particulars, whatever you have given in the form, only that can be changed.
Correct.
Got it? Any doubts? You need to remember this form. It is must. Basic forms. DIR 3, DIR 6. Do not forget. Any doubts still here?
Clear, clear. Sir.
Clear. Okay, so there is one more form called DIR 5. Okay, so we spoke about DIR 3 and DIR 6. Now DIR 5, there is one more form, which is to surrender your DIN. Right? What are the cases that you can surrender? It may be demise of that person, or that person becomes incompetent. Right? Or that person holds a duplicate DIN. See, now it is not possible to have duplicate DIN, because the moment you file that form, right, automatically you will get a technical error saying, look, you have already used this PAN, you have already used this Aadhaar, you have already used this ID proof, or this name is already there in existence with against this ID. Okay, so there will be the moment you file this, try to file this form, you will get a technical error, which means it will not allow you to proceed to have multiple DINs. But initially when the DIN system was introduced, there was no mapping. So people initially they got allotted multiple DINs. So what happens in that case is you need to surrender what are the DINs that you no longer using or you have not registered with the company. Suppose I have a DIN I have given to the company. Now the company has used the DIN for all my filings. Okay, that company does not know I also have another DIN which I'm not supposed to have. In that case, you have to surrender the other DIN, because one DIN you have already used it for filing. Right? So this is to happen initially. Now it is not possible because, as I said, technically you will get a technical error initially while uploading the form itself.
Because now database is mapping.
Correct. Now there is so much of advancement is there in technology. We have tried also. Look, sometimes what happens practically, I'm saying client will come back to you and say, please incorporate a company. We will say, please give me all your details. Please give me your DIN number if you have. The client will bluntly say, no, I don't have any DIN. The moment we start uploading this form, then we'll find out that, oh, this person has already a DIN. Then we'll go back and say, boss, you have lied to us. Initially, no, that guy will come back and say, no, this I'm not aware. My chartered accountant filed, I'm not aware. Or my company secretary filed, I'm not aware. Now, this is a practical situation, but earlier, the moment you file such kind of form, the form used to take and people used to get multiple DINs. Right? Now, how to cancel or what are the ways in which you can cancel or deactivate the other DIN? Okay, point number 1. Last 696, last point. DIN is found to be duplicate in respect of same person provided the data related to both DIN shall be merged with validly retained number. Right? If you have a multiple DIN, then you need to surrender one DIN.
Sir, page number 696, is it?
Correct.
Last paragraph, sir.
Okay, DIN was obtained in a wrongful manner. Fraudulent means you have given wrongful identification number, you have forged documents, you have obtained DIN. In that case, if ministry finds out, then you need to surrender. Death of the concerned individual. Right? If an individual has obtained DIN and that person has demised, right, you can surrender using DIR 5. Who will file? Nominee of that person will file. Obviously, he can't file, right? In case of DR 3, individual he has to file. He is applicant. But in case of demise, he will not be there. His nominee will file. His nominee will say, look, I am this legal nominee. Since he is no more there, here is the death certificate as an attachment. Kindly deactivate his DIN. Right? Concerned individual has declared as person of unsound mind by competent court. Court has said he is no longer competent to be appointed as a director. In that case, you can surrender your DIN. Concerned individual has been adjudicated as insolvent. Okay, in case you have no assets, you are into insolvency. In that case, in order to avoid future liabilities, you can surrender your DIN. Right? Okay, so insolvency case, only in insolvency case, you will be given an opportunity of being heard. If you prove to the court that currently I am insolvent, but I am capable of making money in the future, in that case, you can still continue to hold your DIN. Right? Okay. Now take an example. Ratan Tata wants to surrender his DIN. Can he do?
Yes.
If he does not fulfill any of the criteria in A to E. So A to E is a conditions to surrender. Without this condition, you cannot surrender the DIN.
Okay.
Okay. Suppose a director is appointed. Okay. Say Kushal is appointed as a director, but his DIN has never been used for any filing, or he has not signed any document using the DIN. In that case, only he can surrender. He has to declare that, look, I was appointed as a director, but I have not done any filing using this DIN. In that case, he can surrender. Only and only in that case he can surrender. Otherwise, mandatory.
Because it is not used, that's why.
Correct. He has not used. The moment he uses the DIN, then he automatically falls under this A to E bracket.
Okay.
You need to fulfill any of this criteria.
Okay.
Okay. Now suppose Siddharth, you said you have a DIN.
Yes.
Right. So you have a private limited company, you said, right?
Exactly.
Right. So you will be filing documents using your digital signature.
Correct.
you cannot file the form for surrender of the DIN because you have already used it for filing. Right? Unless you fulfill A to E criteria, A to E, condition given in A to E. Right? So in the given case, do you think Ratan Tata having DIN number 1 has never used his DIN for any filing?
No.
Not possible, right?
Not possible. He is used.
Correct. So which means he cannot surrender the DIN unless he fulfills A to E criteria. Got it right? Please mark this point as important. I'm not saying very important, but important. They will give you a question. Being a company secretary, please advise Mr. A whether he can surrender the DIN. Okay, on what cases he can surrender the DIN. Right?
Category.
Means the point, sir, actually. Sir, which point?
Page number 696, last paragraph, you see. Cancellation, surrender, or deactivation of DIN under Rule 11. Point
Okay.
A2.
Thank you. Yes, sir. Thank you.
Any doubts still here, anybody? I'll stop for 1 minute. Any doubts?
So in all these cases, we should file DIR 5.
Exactly, DIR 5, yes. See, one of our clients we filed, I don't have ready-made with me DIR 5, but nominee file set. Nominee using his digital signature file set. Reason we advise, see, look, even if the director is dead, right? People come to us and say that no, let the DIN be there. Okay, anyway, even though if government initiates any proceedings, they will later find out that that person is no longer there. Why do you want to complicate things? You upfront declare, no, saying this person is not there. So any prosecution that comes under is DIN. Government at first instance, they will not initiate only. Correct. Why to wait for government to initiate? Then when they comes for scrutiny, then why at that point of time you tell them, no, this person is no longer there. Correct. So whenever in any of these cases we advise is better to file DIR5 and be done with it. That chapter is done. I think form fees is around 5,000 rupees for this surrender of DIN. Okay, so just imagine to pay this 5,000, people say don't file. They don't understand the liability that comes actually with this. Any doubts still here? Okay, what is form DIR3 for?
Director's registration.
Application.
Okay, DIR6?
Particular changes.
Changes in DIN.
Okay, now I am a director in the company. I come for before you for your advice. I am saying that, look, I have applied form DIR3. I have got 8-digit number. I don't like this number. Okay, please do the refiling and give me another DIN number. So as a company secretary, what is your advice to that person?
It is not possible to do
Not
so.
possible to give another DIN number. The same
You're able to
DIN.
understand, right? Exactly. So once DIN is allotted, it's a lifetime. Okay. Even if your director or somebody comes for you for any advice, you tell them, boss, this is only one time. You have already filed it. Okay. DIN has already been allotted to you. Okay. Let me just see whether I have a DIN allotment number.
DIN number, I think you can use. Let me check my DIN number.
Okay, you're able to see the screen, right? So what happens is, so once you file this DIR3, okay, so see the director, Aruna, I showed you the form. Okay, so she will get this DIN allotment of DIN, email from MCA, DIN cell, okay, Government of India. Okay, you'll get a letter like this. Okay, this is auto-generated letter, but however, your DIN number will be mentioned here. Okay, that is 3, 4, so till here. 10 digit, out of that ignore 2, it is 8 digit always. 09347542. Got it right?
Sir, as you said, that 0, like Ratan Tata has only number 1 DIN. This is also like we can count, is it? See, so she has around, she's the 93,47,000 like that.
Correct. Yes. I'll show you Ratan Tata. See, you're able to see, right?
Yes, sir.
See here, 000001. Ratan Naval Tata. So using this DIN number, you can actually find out from the ministry, you can track which all companies is actually a director. You director must.
I think the master.
Okay, so right now is holding directorship 1, 2, 3, 4, 5, 6 companies and 2 LLPs. Right? See the status of the company, private. One is foundation, Ratan Tata Foundation, private company, foundation. Foundation is a Section 8 company. You remember non-profit organization.
Yes.
Yes, sir.
Okay, so this is an LLP. Using the same DIN number, you can be appointed as a designated partner in the LLP also, limited liability partnership. So this data will show you when you actually been appointed as a director. Begin date. Got a basic idea, right?
Yes.
Yes, sir.
Yes.
Okay, so come to 697 only, same general provisions regarding DIN. So initially, as I said, say in the year 2006 when DIN provisions were introduced, so existing directors, as I mentioned earlier, got appointed as a director using some ID proof, your PAN, your whatever ID proof was there with them. Okay, so once DIN became mandatory, government advised all existing directors who do not have DIN, you need to mandatorily file this form to get the DIN if you want to continue to hold directorship. This is when initially this provision was introduced, 2006. Okay, so in that case, they said you need to intimate the company in form DIR3, then the company will return intimate ROC in form DIR3C. This is not important. This is initial 2006 provision, but still it is retained. Okay, but I do not know why it is retained, but this no longer in active use. You can say reductant provision only. Right? You cannot be appointed. You cannot continue to hold, continue to be a director if you do not have DIN. Please remember that. Okay, so initially, this provision, initially 3B, 3C provision, see, director to intimate DIN, company to inform DIN to registrar. So which means your director will apply in DIR3, director will get the DIN number, director will inform the company in 3C, sorry, in 3B, saying, look, I have applied for DIN, here is the DIN number, you can use this for all the filing. Then company will say, okay, thank you for intimating me. That DIN will be filed with registrar in DIR3C. As I said, it is old provision, no longer in existence. Rarely we see company use this. Okay. Rule 12A, very important. This form is called DIR3 KYC. Same DIR3, similar to DIR3 is a KYC form, which means every year you file this form with the MCA. Right? Every reason.
KYC, sir. Full form of KYC.
Know your customer.
No.
Basic KYC, basic, same, not different. Okay. So reason, actually this provision was lately introduced, right? DR3 KYC provision. What had happened practically is whenever the show cause notice was given to directors, directors would always go back to ROC and say, boss, I never received this document. You have sent to wrong address. No, you are not liable to prosecute me. This is before your court, before your NCLT. They would argue, directors would argue. ROC had no choice but to take back the case. Right, if a director says, then judge will say, Raya, he has moved to different location, he was not there. Okay, he has changed his email ID. He didn't get the notice. That is why he has not replied to you. But now nothing doing. Every year you need to file this form, which means every year you need to give your updated details. Where are you residing? What is your email ID? Right? Tomorrow you go back, you can't go back in front of your bench, your NCLT, LAT, and say, plead before them saying, Your Lordship, I was not aware of this provision or I did not file the form. Right? Nothing doing. It is up to you, directors. Right? Any doubts till here? DR3 KYC? KYC is nothing but similar to DR6. Any change in the particulars, you will file e-form. Okay, you can note down any change in the particulars, you will file
6.
Correct. 6 and that particular area, this is every year form. That is one time. Your DR6 is one time. KYC is every year.
Okay.
Okay. See, suppose Kushal, you have changed the address. You have filed DR6.
Okay.
Okay, that is one time. You have filed, that is done. Now, as a yearly compliance, you need to file this DR3 form, KYC form. Okay. So in KYC form also you will mention your updated details and file.
Okay.
Okay, so this is for the year in which you actually made any changes in the DR6 form. But let us say you have not made any changes.
Yes.
Then in that case, you just have to file web-based form, DR3 KYC web. Okay, you don't have to upload any form. It is a web-based, which means you just have to log into MCA. Okay, you need to generate a OTP. You will get a OTP in your email. You get OTP in your mobile number. You just have to validate that in the portal and upload. No digital signature is also required because there is no change for the given point in the year. Only when there is a change, you will file this DR6, and for that particular year, you will file e-form. E-form or DR3 KYC. Okay.
Okay. Okay.
The DIR6 is like once in a lifetime thing.
No, whenever there is a change.
So then what's the difference between DIR6 and DIR3 KYC?
KYC is every year.
Okay.
See, suppose you have changed, say your passport has expired. Okay, you have got a new passport. Now the passport number you have initially mentioned in DR3 form is different to now. You will file this DR6 form, correct? Automatically your changes will get updated. Okay. Now in that particular year, you need to file this form, e-form, or only in the year in which you have made any changes to DR6?
Okay, sir.
Okay, and largely people use this form in case there is change in your KYC, your email ID and mobile number. Largely DR3 KYC, they use it for change in mobile number and change in email ID. Okay, using DR6, you cannot change email ID and mobile number. Only using DR3 KYC form, you can change mobile number and email ID. You can note down that. Major difference between DR6 and DR3 KYC. Other particulars other than your mobile number and email ID gets updated in DR6 form. Email ID and mobile number gets updated in DR3 KYC form.
So can you repeat it?
DR6 form, particulars other than your mobile number and email ID.
Okay.
Which means your address, your PAN number, your change in your passport number, or any other details, change in your name only. Okay, all this gets updated in DR6. Okay, suppose you want to update your mobile number and email ID only.
Okay.
Okay, other details being the same as DR6. In that case, you will use e-form DR3 KYC.
Okay. And this DIR3 KYC.
Web KYC, no change. Same as last year.
Okay.
You don't want to make any changes to your email ID, don't want to change any mobile number. In that case, you just have to file this web form. Web form, it will hardly take you 2 minutes.
Okay.
You just have to initiate OTP. Okay, like you purchase anything from the websites, right? They'll ask you for OTP for making payment. Similarly, in MCA for KYC details, similar thing will happen. But for web KYC, you need to upload forms.
Okay. And for example, I have changed the address.
DR6.
So DIR6, but every year I have to file DIR3, right? So in that also, should I mention it?
Only in the year in which you have changed, in that particular year, you can file this e-form.
Okay. In that also I have to mention, right? In that year, I have to mention the change in address. In the subsequent years, no need to mention.
No need, because it's already updated, right?
Yeah. Next year is only web KYC.
Correct. If there is no change in your email ID and mobile number, web KYC. If there is change in email ID, mobile number, DR3 KYC form.
Okay.
Other than email ID and mobile number change to any other particulars, DR6.
Okay. And you mentioned about eKYC. What is that? Which one is
Same. eKYC is the form. eKYC is the form.
Form. Okay.
Web KYC is the no change one.
Yes. Okay.
Is that the information which is available in the MCA portal? That screenshot you are re-uploading to the ministry to confirm.
Exactly. Wait, let me show you how it looks. I think you need to. Okay, I'll show you next time because I think site is undergoing maintenance. So that is the reason I'm not able to view that web KYC. Okay, in DR6 and DR3 KYC forms, it is you need to upload the form using your digital signature. But whereas web KYC, no digital signature is required. You just have to go log into the portal and verify your OTP and do it. Okay. So any doubts still here? Okay. What happens if the director does not do KYC every year?
KYC? Can you repeat, sir?
If it does not do KYC, DR3 KYC, if it does not do
PIN number gets
every year,
deactivated. PIN number gets deactivated.
right? So if it does not, correct. So if it does not do his KYC every year, his DIN number, status of the DIN automatically changes from approved to deactivated due to pending KYC,
Okay.
right? However, it does not lose his directorship.
Once the KYC is done, the DIN number gets reapproved.
Correct. It can be, it gets reactivated, which means you can file any documents only using approved DIN. So the moment you don't do his KYC, you cannot use his DIN and file documents. The MCA portal does not allow, because you'll get a technical error saying KYC has not been done. Okay. Any doubts still here? So what is the due date is 30th September every year. 30th September you need to do it. On or before 30th September you need to do it. Okay, suppose I forgot. Okay, my advisor, my company secretary did not advise me. He didn't have the knowledge of this provision. Okay, so what happens if I file on say 1st October? In that case, still you can file, but you will be levied a penalty of 5,000 rupees. Right? So, otherwise it is free. You will not be charged anything, because since it is a yearly compliance, form filing fees will be 0. But if you exceed the due date, you will have to pay 5,000 and then get your DIN reactivated.
Okay. And what is the status? What will be the status deactivated with?
Deactivated due to non-filing of DR3 KYC form.
Okay, sir.
Okay, please remember, he does not, director will not step down. It will not affect his directorship. He can continue, but remember, using his DIN, you can't file any documents. Right? Because the moment you enter his DIN in the form, it will say, please enter valid DIN, approved DIN. Okay? Page number 698. Impact of non-compliance of DR3 KYC / DR3 KYC web. So within September, as we mentioned, if it does not file, his DIN becomes deactivated due to non-filing of DR3 KYC. Then once you pay the fine, and then you can reactivate your DIN. Right, any doubts?
No. Director's
No.
part, DIN part is clear.
Clear, right, DIN?
Yes.
See, summary of DIN is given there. Just go through once, whatever we have discussed, only same thing is provided here. Important one is DR3, DR6, DR5, DR3 KYC / DR3 web KYC. Okay, when do you file web KYC?
When there is no
Correct. So details, whatever you have already given for the last year, preceding year, is same. There is no change. You will file web KYC. Whenever there is a change in mobile number and email ID, you will intimate using e-form. Other than these two, any change you will intimate in DR6.
DIR 6.
Okay. Any doubts still here?
Sir, what's 3B, 3C?
No, you remember we discussed it. This provision was introduced initially when the DIN provision was given.
Okay.
So that case, when directors were allotted in, directors' responsibility to intimate the DIN to the company, and company in return intimates to the ROC.
Okay, sir. Yeah, got it.
And also, I think 2 years or 3 years back, what was the provision is any individual, even without getting appointed as a director, still can apply in this form DIR3 and hold the DIN number. That was permissible back then, 2-3 years back. Okay, even though I don't want to be appointed any director, meaning as of now I'm not holding any directorship, but I am thinking, okay, in another 5 years I will become director in Infosys. So let me have DIN from now only. So initially, when after 5 years, say if Infosys offers me a directorship, I can just show them that, look, I already have a DIN. Kindly appoint me. That was their previous. But right now, there is no such provision, which means you need to prove that, look, I have actually got this offer from this company to be appointed as a director. That company has to pass a board resolution granting in principle approval. Okay, the board has to say, I have identified, okay, this person to be appointed as a director. Here is my in principle approval, board resolution. Basis that in principle approval, then I will use that in the form DIR3. Okay, then the applicant will sign, the company in which proposed to be appointed, that director will sign and upload.
Okay. And DIR 5, as you mentioned, if you have not done any transaction for a long period, you can surrender it, right?
Not long period. Even though if you have done anytime once also, you can't surrender.
Yeah. We have not done anything. But for how many years we should not have done something?
There is no year. From the initial, from the procurement, you should not have done anything. No filing should be done.
Yeah, but for how many years? Like?
Until that person fulfills any of the criteria in A to E.
Okay.
Okay. Look, you are able to see my screen, right?
Oh, yes, sir.
See, in this given case, okay, so Aruna wanted to apply DIN number. Why she wanted to apply is, okay, this company, Capillary Technologies Private Limited, offered her directorship.
Okay.
Okay, so that is the reason she is applying for DIN. Now, what the company, see, look, this is a resolution, which means company is granting in principle approval. Certified true copy of the resolution of the minutes of the Board of Directors of Capillary Technology Private Limited held on so and so date. Okay, what is the agenda? To consider the candidature for candidature and authorize the board for proposal of the name, okay, so and so, for application of allotment of DIN. This is common across all company. There is no change. Even if Wipro wants to appoint any person as a director, it needs to grant in principle approval for application of DIN. Only once the DIN is available, then next process, appointment starts. Right?
Okay, sir. So they have to pass a resolution for circulation, right?
Resolution is of two types. One is in person,
Yeah, VC
physical and virtual, or resolution by circulation. Don't get confused.
Okay, but what they have to pass in order for them to appoint a director?
Check whether it is falling under 179.3 basic. If it is not falling under 179.3, then you can also pass by way of resolution by circulation. Simple.
Yes, sir.
Okay, this does not fall under 179(3) in principle approval. So which means you can also pass this resolution by way of circulation. In the given case, the directors have met at Bangalore. Okay, and then they have passed this in principle resolution.
Okay.
Okay. So without directors, without company coming forward to appoint a candidature for directorship, you cannot have have individuals applying for DIN in DR3 KYC, because the company in which getting appointed, they need to pass in principle board resolution, and directors have to confirm or sign the form, right? So today, me or any one of you wants to apply for DIN, it is not possible unless you have an offer letter from any company, any proposed company, to become appointed as a director. You need to have the in principle approval. However, if I want to start a new company, in the SPICE form only I can appoint. There is no in principle approval required in that case. You are able to understand, right?
Yes.
Yes.
In the incorporation form only I can apply for DIN. In that case, there is no proposed company only. So the moment there is no proposed company, resolution does not apply.
Correct.
Okay, any doubts still here?
No, no.
Okay, in page 698, directors, type of directors. Women directors we have already discussed. Can anyone tell me women directors provision?
All the listed companies and the public companies by the 99.9%.
Listed company provision is correct, but the other provision is not correct. Women directors, come on. You remember discussing this provision, right? Women
Yes,
director.
sir. Composition of board of directors we are discussing.
Nagendra, you are trying to say something. You're on mute. Mute. Unmute, please. Nobody. You guys are not revising. That's why you are not able to recall the provision. Still not audible. No, I think Nagendra is trying to speak.
All listed companies should have woman director.
Okay, what is another provision? What about for private company, public company?
Sir, public company, the paid up capital of 100 crore rupees within 6 months, we need to appoint a women director, sir.
Within 6 months is correct. Could you please repeat what is the paid up capital?
Sir, 100 crore rupees.
Okay, is there any turnover?
300 crore.
100 crore, turnover 300 crore and more. All public companies and all listed companies. Under section 149, subsection 1.
Got it right? Any
Of the
doubts?
company.
See, we have already discussed. I think the moment we start revising, you should be able to tell here. Otherwise, no point. Right? You need to go back. That's why I'm keep repeating this. You need to go back and remember all this. Otherwise, you will not have that continuity. Lot of, as I said, one provision is interlinked with another. Women directors, any doubt? We have already discussed this. No doubt.
Okay. No.
Women directors, I have already, a company has appointed women director. Okay. She has resigned. Now company is coming to you with the advice saying, when should I appoint another woman director to replace her?
Within 3 months.
Within 3 months or general meeting if it's held. Board meeting. If board meeting is held, whichever is lower, they have to pass that resolution to get the women director.
Within 3 months or next board meeting, whichever is later, right?
Yes, sir.
Any doubts on women director provision? We've already discussed. Okay, you need to remember the paid up capital, you need to remember the turnover, you need to remember. I'm saying very, very important provision. Women director, you will get one question mandatory. Okay, resident director. We have also discussed about resident director.
Who has stayed in India for more than 182 days in the correct year.
Simple. Very nice, Kushal. Simple. Right? Resident director, easy provision. Okay, now 2 persons from China have come for you, before you, to take your advice as a you being a company secretary. Okay, yeah. So there are 2 Chinese persons. They want to start company in India, private limited company. You advise them whether they can incorporate a private company in India.
I have a doubt, but like one should be resident, another should be person appointed by the company itself, but for which I am not sure, private or public.
Okay, what is the composition of private company? Directors?
2. Minimum.
Minimum 2 members to be director.
Public company?
3.
Correct. Now 2 Chinese guys have come to you. They are saying, please incorporate a company in India. You are a company secretary, you need to advise them.
One should be resident, correct. One should be resident, another can be any person appointed by the company itself.
Anybody? Look, all this we have already discussed. You just have to recall, or if you have revised, you should be able to answer. See, this resident director concept, if you remember, I had given an example saying you need to have a person in India so that the person can understand the compliance of India. Right? He has to know the law in India. If you say 2 persons from China are coming into India to incorporate a company, then which means they both are also not aware of the law in India. So how do you expect them to comply with the provisions of the Act?
They need an Indian partner.
Right, so which means they will, being a company secretary, you need to tell them, boss, you need to identify any individual as a resident in India, or you yourself be a resident in India, fulfilling the criteria of 182 days. In that case, I will incorporate a company for you. Other case, you find the individual who is already in India so that that person can understand the Indian law. So then only I will be able to help you to incorporate a company in India. Otherwise, it is not possible. 2 Singapore nationals cannot incorporate a company in India. 3 US nationals cannot incorporate a public company in India. You need to have 1 resident director in India so that that person is able to understand the law and able to advise other directors, other foreign nationals. Do not forget this. You are able to understand the logic.
Yes.
Yes.
Now I got it.
Sir, but in the board constitution have they given this, sir? In the CSR they have given, but in board also they have given, is it?
Yeah, resident director concept across the board only, right?
Yes.
So if you have 5 directors on board, maximum that you can have foreign nationals is 4. One should be Indian only. That is your resident,
Okay.
right? That person can be either male or female, whatever. That is not a problem. But you need to fulfill that resident criteria.
Okay, sir. Minimum one.
Minimum 1%. Right, you will get a question like this. 2 persons from South Africa have come before you. You are a company secretary. Okay, please help them incorporate a company in India. Okay, so you need to quote this provision and say, look, boss, this is not possible. Okay, tell me one thing. Can I have 2 shareholders from China? Okay, Chinese national took your advice. They will have one resident in India. Okay, another one will be Chinese.
Okay.
Now they are saying, okay, directors can be Indian, but I want 100% control of that company. I will make sure that all my shareholders are from China. I don't want to give any shareholding to any Indian person. Is that allowed?
No.
Manoj,
Yes.
just a second. Manoj, can you repeat again the statement? You're talking about saying 2 Chinese nationals who came to us in front to us as a CS and asked for our advice in terms of registering. We explained them that under this section, either you need to find a resident Indian partner, or one of you has to be in India for 182 days in order to become applicable for that. But now the scenario is they have an Indian partner who is looking after the compliance. Now they are coming, they are saying we want to get a company registered, which is where they want to have the 100% holding.
Correct. Correct.
So in the year of, other than the year of incorporation, they will be permitted.
I guess they can have, sir, but just like any other company who can have their foreign branch here, right?
No.
So look, this resident director is applicable only for a directorship. Shareholding, you can have shareholding 100% any country. There is no problem. Right? There is no provision that you should have a resident shareholder. Right? Only provision is resident director, so that director has to comply with the law. Being a shareholder, how are you going to comply with the law? You are only given agenda items to vote and you exercise that voting rights. Right?
Correct.
You are able to understand, right? Shareholding can be 100% any country, no problem. But directorship, minimum one resident director should be there. Any doubt between directors and shareholders?
No, sir. And shareholders can be directors also, right?
Correct. They can be same person. 2 individuals who are becoming directors can also become subscribers to memorandum. That is, same individuals can hold the shares also, no problem. That is allowed. Or you can have different persons. That is also allowed.
Yes, sir.
So Siddharth, in your case, you and your mother are directors. Right? You can have the entire control. You and your mother can hold shareholding, no problem. Or you can sell the shares to anybody outside India. They can 100% control your company. Even though you are residents in India, whatever you are placing matters before shareholders. Right? You have no control over voting. Your control is with the outside India only, because they will vote. You're only proposing the matter before them.
Because they hold the shares.
Correct. They hold your voting rights, right? So in terms of shareholding, there is nothing mentioned in the Companies Act that that person should be resident in India. Only for a directorship it is mentioned.
Okay.
Any doubts still here?
No.
Very basic. I will not repeat this going forward. Any doubts still here, you can ask me right away. I will explain once more. Women director provision, resident director provision.
No, sir. Clear.
Okay, tell me, company has A Limited has turnover of 500 crore. It has 3 directors on board. Okay.
Turnover.
One director is from US, another director is from Malaysia, and another director is from India. Right? Now that Malaysian director happens to be woman director. Is it allowed?
Yes, sir.
Yes, yes.
Yes, it is allowed.
So woman director can be anybody. It can be from India or outside India, no problem. Right? So make sure you have, the moment you trigger the provision, make sure you appoint some woman as a woman director. Got it right? Any doubts? You want me to repeat anything? Okay. Okay, first director. Who are first director? Person who are incorporating the company. Right, today I want to incorporate a company. At the spice form we discussed, right? Spice form I need to disclose who are the directors, who are the shareholders. If nothing is mentioned, person whose name is given in the Articles of Association, AOA. At the time of registration, you need to have your memorandum and articles. So your articles contains who are your first directors. Right? Your spice form contains this. So those are deemed to be the first directors. Any doubts? Who are the first directors?
People who are incorporating the company or names that is mentioned on the Articles of Association and your Memorandum of Association.
Memorandum does not contain first director's name, only articles.
Articles. So whatever the name it is contained in AOA, it's by default becomes law of reflects in
Correct.
that MOA.
Correct. So your articles contains who are your first directors, right? Your spice form, you need to specify who are your first directors. Okay, they become your first directors. Okay, so the moment you are incorporating the company, you cannot say at later stage I will appoint director. Upfront, you need to disclose who are your directors, who are your shareholders. Got it right? First directors. So in the directors thing, first directors concept is clear. Resident directors concept is clear. Women directors concept is clear. Right? Now you come to small shareholder director. I will come back to independent director. Small shareholder director. Right? So this is applicable only to listed company. Not applicable to public company. Not applicable to private company. Only listed company. Listed is equity listed on BSE, NSE, Bombay Stock Exchange and National Stock Exchange. Right, only listed company. So your Wipro, your Infosys, all these provisions, small shareholder director provision is applicable only to them. Okay. So what happens in this case is, so any person that is holding less than 20,000 as a nominal value, share value, he can propose another person as a director, representing him as a small shareholder director. Right? suppose you are a shareholder holding just say 10,000 value worth of shares. You can propose another director's name to Infosys saying, please appoint him as a director. I propose this candidature to be a director of the company. Right? In order to propose that directorship, you need to have a value shareholding in that company less than 20,000. If it is more than 20,000, you cannot propose that candidate. Your value should be less than 20,000, nominal value. Only in that case, you are eligible to propose any person to be small shareholder director. Only for listed company. Any doubts? Section 151.
Sir, can you repeat it, sir? Once.
See, shareholding, we spoke about shareholding, right?
Yeah.
So out of that shareholding, you may have such kind of shareholders who are holding, say, value of 5,000, 10,000, or maximum 20,000.
Yes.
Okay, this is not private company, not applicable to public company also. It's only for listed company. In that case, the provision says you can propose a candidate representing you, representing that small group, okay, to hold the directorship in that company, one person. Okay, suppose I am holding say 15,000 value of shares. I can propose myself. Look, I want to be appointed as a director. Here is my proposal.
Okay, sir. But if you have more shares, you can give your name to become a director.
Maximum 20,000 value. 20,000 value.
Okay.
This is allowed. You can propose a candidate. Right, today, if you are holding shares of Infosys, which value does not exceed 20,000, you can propose, you can apply to Infosys saying, dear sir, I want so and so person to be appointed as a director of the company under the head section 151 as a small shareholder director.
Okay.
No, you can appoint, say for example, as you're saying, say if I'm holding, say about say 17,000 worth rupees of shares of Wipro or Infosys, I can nominate myself also to be a small shareholder.
Yes, you can nominate, yes.
So you have to write it to the Infosys board stating to appoint myself as the small shareholder of the company.
Correct. Now you tell me what happens then. After that, what happens? You get an application, you send out the application. Now you tell me what happens. Just relate what we discussed prior to this, prior to immediate and previous class. The moment Infosys receives this letter, what happens?
They will look out for DIN number.
Exactly. So which means first thing is they will
look out for DIR direct existing. If you are holding a DIN number, they will ask you for the DIN number in order to put your application to MCA portal. If you don't have, then they will create a digital signature token and they will do DIR3 file. They will do for registering yourself as a director. If I'm not holding DIN.
Okay.
Because
partially right. Anyone can correct him and clear this. You tell me where does this matter go? We are taking example of Infosys, right?
Yes.
It's a listed company.
Yes.
Does the matter directly go to the board, or before going to the board, does it go anywhere?
It goes to
resolution need to be passed. Shareholder resolution. That's it.
Anybody else? Think. What does NRC do?
Nomination committee.
Listed company, it is by default applicable, right?
Yes, they have to.
So the moment you receive such application, where does it go? It goes to your non-rem committee, right? Because they are the one who takes care of your appointment of directors and KMP.
Yes, correct.
You have to understand. You need to relate.
Okay, correct. But why are they not exceeding 20,000? Is it it will become joint venture? Is it like that? More than
No, this is not your holding percentage. It's not your percentage. This is just a nominal value.
okay, 20,000 rupees worth of shares.
Correct. Reason being is, since you fall under that minority shareholder bracket, they want somebody to represent them on behalf of the board.
Okay.
Okay, they also want to know that what is going on in the company. If somebody majority is controlling the company, who's holding more than 75%, all decisions will be taken by him only, right?
Correct.
Other minority shareholders does not have any say. In that case, the law wants to make sure that person who are holding minority shares also have a board seat, may also have a board seat, so that they also get to know what is the agenda that is being discussed at the board level.
Okay, yeah.
Okay, now who is required to make this application? Read these rules of them, terms and conditions. Not less than 1,000 small shareholder.
Or 1/10 of everything.
You need to get application from these many people. Minimum, bare minimum, not less than. So which means I need to make sure, I need to convince 1,000 small shareholders that, boss, please nominate me for small shareholder directorship, or 1/10 of total number of such shareholders. Small shareholders say there are about 120. Out of 120, I need to convince 1/10.
12.
Okay. Not less than this or this, whichever is lower. I need to convince them and say, please propose this candidate or please propose me as a directorship. Got it right? Whichever is lower.
Yes.
So any of the conditions, if it is not met, you cannot appoint under this category. Small shareholder director category, you cannot propose any director.
Okay.
Okay, now take an example. A is a listed company. Okay, B is a private company. Okay, whether small shareholder directorship concept is applicable for B private company. A is a listed company.
Only listed company can have small shareholders.
Okay, tell me what is the status of private company, B private company?
It doesn't have to have a small shareholder.
No, what is the status of B?
A status.
It's an independent company.
Whether it is a listed company, whether it is a public company, whether it's a private company, I want to know the status.
Company.
Private company, not listed.
Sure?
Yes.
Who is holding that company?
Sir, you did say it's holding.
Holding is a listed company. Holding is a listed, subsidiary is a private company. Now tell me the status of B, private company.
So it's a listed company, deemed listed.
Deemed public.
Chetna is right. It does not automatically become deemed listed. It only becomes public. You're able to understand, right?
Yes,
Public company controls private company, deemed public company. Listed company controls private company. It does not become deemed listed. It only becomes public. So in this case, B is not required to bond by this small shareholder director concept because it is applicable only to a listed company. Any doubts still here?
No, sir. Clear.
Okay, I will pause here for 5 minutes. I think you're done with the time. 5 minutes. You have any doubts with today's topic or previous topics? Please ask me. Please get your doubts clarified. Don't make sure that you're right with wrong with the concepts. Get the concepts right. Otherwise, your entire Companies Act will go for a toss. Okay, can anyone summarize who are the first directors other than Kushal, Siddharth? You guys are already speaking. Okay, Chetna also, other than these three. First directors, please. Who are first directors?
Is a person who
Person who incorporates the company.
memorandum of association.
Anyone, please. I couldn't hear, sorry. Okay, Anupama, I can go ahead. Yeah.
Is a first person.
First directors. Who are there?
The persons who are incorporating the company and whose name is mentioned in the articles of association.
Okay, perfect. First directors done. Who are resident directors? Okay. Other than
The person who has the certificate with the 180 days
for
only.
not less than 182 days. They are the resident directors.
okay. Okay, is there anything like resident director has to be from India or outside India?
No, if at all a foreign national also has to be a resident of, director of India, he has to stay here for 182 days to claim his directorship.
Perfect. So that is irrespective of person being a male or female, right?
Yes.
Okay, perfect. Women director, provision? Whether private company need to appoint women directors?
No, all listed companies should have at least one woman director, and the public companies where the paid up capital is rupees 100 crore or more, or the turnover should be 300 crore or more. They should have at least one woman director.
Perfect. Okay, perfect. Now say Wipro Limited has incorporated a subsidiary, which is a private company. Okay. Private company turnover is 1000 crore. Now you tell me whether independent women directors provision is applicable to you or not. Wipro Limited has incorporated private company, right? Private company's turnover is more than 1000 crore. You tell me whether women director's provision is applicable.
No, sir.
Reason?
Because it's exclusively for all the listed companies and public companies, but not private.
Manoj, you said Wipro Limited incorporated a private limited company, and for that,
Right.
you are saying a woman directors and the turnover of that private limited company is 1000 crore. Women director provision will be applicable because by default that private limited company is deemed listed public company.
Deemed public.
Yeah, so it's deemed public company.
Deemed public. You're able to understand?
Yes.
They have to form a women director. Have a women director.
Correct. See, the moment you say any company, private company, which is controlling by public company or listed company, straight away, just see that private company status as public company. No doubts.
Yes.
Right? The moment you are able to establish this relationship, make sure you read that private company as public. Got it, right?
Yes.
Yeah, got it.
Okay, take an example. Wipro Limited owns 100% of the capital in B Private Limited. Now the company secretary is coming to you for advice whether nomination remuneration committee or audit committee is applicable for that private company.
Audit committee no need to form because it's only on subsidiary.
Correct. What about NRC?
Doubts.
NRC also not recommended because the company is itself is getting 100% holding. That means
Correct.
it's a part of it, so there is single committee can handle that.
Correct. So you need not to have committee. Audit and NOMREM, that 3 exemptions are applicable for both.
Okay, sir.
Right. WOS, your dormant, okay, your JV.
JV.
Okay. Please go back and revise. Okay, today, especially today's topic, directors very important. Okay, don't get the basics wrong. Okay, so I am more worried because tomorrow if you speak to any professional, they will say, who taught you Companies Act? Then you will say, Manoj. Then that guy will say, lady, that guy didn't teach you well. What has he taught? They will not tell you. They will scold me.
No, they would know what is Manoj. They will scold us. You have not put in your effort.
Cell is popular.
One last question. In DIN provision, 3B and 3C right now is not in effective, right?
Correct. Right now it is not used. Initially, as I mentioned, when this DIN rule provision came, person who was appointed as a director using some ID proof. So those guys has to, when the rule came, they had to apply for DIN to continue directorship.
For that reason, these 2 provisions were applicable, but right now it is mandatory to.
Right?
Okay.
So tomorrow, if somebody says, I want to be appointed as a director, basic requirements you tell them is DIN. And you tell them the form that you need to file. Got it right?
Yes.
Sir, one doubt. For joint venture company, more than 20%, right?
20 between more than 20 to 50. That is your JV, significant influence.
Yes. Okay.
20% to 50% of the stake.
More than 51 means it will become subsidiary.
100% becomes WS, fully owned subsidiary.
Yes, sir.
Got it right?
Yes, sir. Got it.
Please remember the forms. Very important, okay? Okay, then take care. We'll see you next class. Please go back and revise my humble submission. Okay.
Sure.
No, reason I'm repeating this is because I know, look, book is 1000 page. Okay. And you will not have time to revise these entire topics in the given 5 days or day before exam. You need to start making short notes, start revising day to day, right?
Yes, sir. Correct.
And also one more thing I want to say, if you're thorough in Companies Act, no, the moment you step into professional, there are 3-4 subjects, it will be like this. You will crack that subject like this because your foundation is strong, Companies Act.
Okay.
There you will have corporate listing, there you will have secretarial audit compliance. All base starts from Companies Act. If Companies Act is good, your professional 3-4 subjects you will clear cakewalk because you are thorough with basic concepts in Companies Act. Got it right?
Yes, sir.
Okay.
Okay, then take care. See you tomorrow, right?
Right. Thank you.
Thank you.
Thank you, sir.
Thank you, sir.